Welcome and thanks for joining us. My name is Kara Bloomberg and I'm the Chief Operating Officer of LandrumHR. For those that aren't familiar with LandrumHR, we're a professional services firm with 50 years of serving clients across the country. We provide PEO or HR services that include payroll, benefits, workers' compensation. We also provide worksite management, a customized labor solution for companies that use large numbers of temporary workers. Our HRQ division focuses on 3 integrated services: enterprise-wide human capital consulting, providing interim HR talent, and conducting searches for HR professionals. Our consulting team brings a depth of experience in workforce planning and analytics, talent management, and talent strategy projects, org design, and HR transformation needs. You can find out more about all of our services by visiting our website, LandrumHR.com and HRQinc.com. A couple of housekeeping items before we get started. A recording of this webinar will be sent to everyone who registered. Please feel free to ask questions using the question pane in the control panel. We have a number of members of our finance team that are on the webinar today, and we'll work to answer your questions as we're in the presentation. If we don't get to your questions, we'll follow up with you. There's going to be a quick survey that pops up as you exit the webinar today, and we would really appreciate your feedback. It's my pleasure to introduce our General Counsel for LandrumHR, Amie Remington. Amie spent the last 15 years of her career at LandrumHR. She has over 20 years in the employment law arena and is a national speaker on employment law topics. Amie, I believe we're going to kick off today by asking a poll question of our attendees before you start your presentation. So I'm going to kick that off now.
Right here.
So our first question today with our attendees are, how do you stay up to date on changes in employment law? And so answers being, we have legal resources on staff. reading blogs and news sources, watching videos and webinars, or other ways. I hope some people will say other and say we use LandrumHR for all of those needs, right? So I'm just going to give a couple of seconds for attendees to respond. Would love to hear from you today. Give Amie a good idea of how you're keeping up with the changes, and wow, there's just been an incredible amount of employment law changes in the last year. I'll close this out, Amie, and share the results. So 56% reading blogs and news sources, so lots of reading from this group. 22% watching videos, watching webinars. 17% we have legal resources on staff, which is great, and 6% other. So thanks everybody for participating in our first poll. Amie, the employment law
changes.
Thank you, Kara. Yeah. The employment law changes over the last year are just staggering. I know our legal and compliance teams and our HR business partners, it feels like we just can't catch our breath in between all the legislation. So thanks so much to you and the team for preparing these webinars and helping us sort through all the information, and we'll get started.
Absolutely. It is completely a team effort here at LandrumHR. Today, we're going to talk about the American Rescue Plan Act and the major provisions of the Act that affect employers of all sizes in so many industries throughout the nation. The Act is a 600-page law with a $1.9 trillion in spending amount. And it's designed to help individuals and employers who have really suffered and struggled during the pandemic. So before we specifically talk about the Act, I want to remind everybody about the legislative history, just in terms of where we've been over the past 12 months, because we have had so many new laws, and the American Rescue Plan Act draws on those laws. And so when I talk about those laws in a few minutes, I want everybody to kind of remember where they started and what those laws said. So by way of history, it has been a monumental 12 months of really complex federal employment legislation. It started in March of 2020 with the Coronavirus Preparedness and Response Supplemental Appropriations Act, which was an appropriations act that appropriated $8.3 billion to fight the spread of COVID. And part of it was for research and part was for public health. And then, of course, there was the Families First Coronavirus Response Act, which we'll talk about at length today because there are components today that matter. And I'll be referring to it as the FFCRA. So when you hear me say FFCRA, I'll try to remember to say the whole name, but I may not. And then, of course, the Coronavirus Aid, Relief, and Economic Securities Act, which is the CARES Act. And that delivered $2.2 trillion in economic stimulus. And it included the PPP, the Paycheck Protection Program, that provided loans and loan forgiveness for American business. And part of the laws that we'll be talking about today have to do with the PPP. There was the PPP and Healthcare Enhancement Act, and there was PPP Flexibility Act. And then there was another bill to extend the authority for the PPP. And then finally, in December, there was the Consolidated Appropriations Act, the CAA. And then fast forward 3 months, and the American Rescue Plan Act was passed, which is about $1.9 trillion. And I should have mentioned that the Consolidated Appropriations Act was $2.3 trillion. And it's interesting because when we start talking about billions and trillions, the numbers just seem so large. And the laws are so complex, and they really do evolve from one another, and they wrap around each other. And so we have to remember these different laws as we move through today. So what I tried to do for today was to really sort through the American Rescue Plan Act and determine which of the provisions really affect employers. And the ones that I believe have the most direct effect on employers and employees in the United States include the Families First Coronavirus Response Act and those extensions. There are new provisions to that. the Affordable Care Act subsidies, dependable care FSA changes that are allowed, the COBRA subsidy program, and then of course the Employee Retention Tax Credit, which you'll commonly hear in the news referred to as the ERTC. So these are all portions of the American Rescue Plan Act, and as I said, they draw largely from the laws that were passed in the past 12 months. So we'll talk about each of those individually. And let's start with one of the original ones, the Families First Coronavirus Response Act. And the Family First Coronavirus Response Act, or the FFCRA, was first passed in 2020. And you'll remember it was the law that said that if you were a sizable employer, that certain paid leave was eligible to employees. And the law was initially for the period of April 1 of last year to December 31 of last year. And it was made up of the expanded FMLA, the Expanded Family Medical Leave Act, and the Emergency Sick Paid Leave Act. And the expanded FMLA was the portion that said that if your employee was unable to work or telework because they had a child and that child's school or daycare was closed or they didn't have child care services, that person could take job protected leave. And then there was another provision, the Emergency Sick Paid Leave Act, which allowed job protected leave under 3 circumstances for employee-related reasons, and they were all directly related to COVID-19 and quarantines and taking care of yourself, or for employees' family-related reasons. So if the employee or their family was subject to a quarantine order, or if their child care or family care was closed, then they had job protected leave. And there were caps on the total time allowed and caps on the maximum amount that had to be paid. And the reason that this is relevant is because these reasons still exist under certain circumstances. Now, the mandatory leave first expired on December 31st of last year. But then the December 20th stimulus bill allowed employers to voluntarily extend the time for any FFCRA leave another 3 months. And that 3 months actually expired yesterday. And it meant that those employers who did voluntarily extend the FFCRA leave to its employees could continue to receive tax credits for that period of time. So as March 31st drew closer, employers and employees both wondered if the amount of leave or the credits would end, or if the leave would end. Well, the American Rescue Plan Act answered this, and it expanded it again. And what it says now is that employers can voluntarily extend the FFCRA leave for another 6 months, which is basically all of Q2 and all of Q3 until September 30th, and still receive tax credits to cover 100% of the cost related to those leaves. Covered employers can decide to offer both leaves or neither leave. That's okay. It's totally voluntary. But one thing that you need to think about as you determine if you want to further extend the leave is that there are some additional rights. So the additional rights come in the form of, for example, additional time off. The 10-day limit on paid leave restarts on today, on 4/1, and it ends on on September 30th. And it basically allows the covered employer to allow employees an additional 10 days or 80 hours and receive a tax credit for that whole time. Additionally, in addition to the 6 reasons that I listed a moment ago about somebody who has COVID or is taking care of somebody with COVID as being a qualified reason for taking leave under the FFCRA, now employers may provide for the emergency sick paid leave for any time awaiting COVID test results. So if somebody's taken a test and they're awaiting their test results, if they have obtained the vaccine, or if they're recovering from any injury, disability, illness, condition, or anything like that that's related to the vaccine. So if somebody gets the vaccine on a Monday and doesn't feel well on Tuesday or Wednesday, that can be a valid reason for the emergency sick paid leave. And pay for these new reasons for leave will be at 100%. Now, there is a maximum of, as I said, of 10 days or 80 hours, and a maximum amount of pay of $511 a day or $51.10 for the total of the 10 days. So there is a maximum, but that maximum is quite high. It also provides for additional 12 weeks of expanded Family and Medical Leave Act. So that means that covered employers can provide employees with an additional 12 weeks of expanded FMLA leave at 2/3 of their rate of pay, including the first 2 weeks, which was previously unpaid. You might remember that from last year. It also increased the maximum from $10,000 to $12,000. And again, that period of time begins today and runs through April 30th. And so that's the expansion of the FMLA, but it also allows similar reasons for need for leave for the FMLA. So again, if somebody needs time off because they're waiting for COVID-19 test results, if somebody needs time off to obtain the vaccine, or if somebody is recovering from the effects of such vaccine, that's another reason that the expanded FMLA could be applied. Now, employers cannot have a discriminatory requirement, and what I mean by that is if you're an employer and you discriminate in favor of your highly compensated employees or in favor of your full-time employees or on the basis of length or tenure, that would be that would violate the non-discrimination requirement. So it has to be applied equally across the board to your employees. So the IRS's website is something we're monitoring because the IRS has done a fantastic job throughout this whole pandemic of keeping its website up to date with FAQs that are really helpful. So we'll continue to monitor that. And then Kara, I think we were going to ask the poll question on FFCRA.
Thanks, Amie. Yeah, so now that you've spent some more time explaining the voluntary extend leave opportunities, we'd love to hear from our attendees if they intend to voluntarily extend those leave rights under FFCRA. So yes, no, or unsure. Just give our attendees a few seconds to give us an answer here. All right, and we'll close it out now. Appreciate everybody responding. A lot of people still unsure, Amie. 53% saying yes, 13% no, and the rest of our attendees that responded, 33% are unsure. So may need to cover some more information here on the FFCRA in the future too.
Absolutely, and our HR business partners are very well versed in this, so they can help our clients determine what works best for them. So, Kara, let's move on to the Affordable Care Act subsidies. So, we talked so much about the Affordable Care Act last year and in prior years. And the American Rescue Plan Act expands eligibility for premium tax credits to make ACA coverage affordable and available to more Americans. That's the kind of summary of it. The ACA Marketplace Subsidy was previously provided to people whose household incomes were up to 400% of the federal poverty level. And if you're curious as to what 400% of the poverty level is, you can just Google that up, and it has to do with how many members of your family you have, and it gives you a very easy way to determine what 100% is and what 400% is. But that 400% was called a cliff subsidy because if you earned anything over that amount, you were completely ineligible. So if you were at 401%, you were completely ineligible. Well, in 2021 and 2022, the law temporarily allows those individuals who are up to 400% of poverty level to qualify for the ACA coverage, and it's graduated over the 400% mark. So what this means is if you make over 400% of the federal poverty level, you may still qualify for an ACA subsidy as the cost is limited to 8.5% of your household income. So that's 8.5% of your household income. It also contains a provision whereby anybody who receives unemployment compensation during any week in 2021 is eligible for ACA coverage at no cost. So another change is the change to dependent care FSA accounts. And those changes also benefit employees. The amount increased from $5,000 to $10,500 for the year. The one thing I will tell you is that while this is optional for employers, if an employer does opt to make this change and allow this increase from 5 to 10.5, the employer must amend its plan to make it effective. So it does require some action on behalf of the employer to make it effective. Okay, now we're going to talk about COBRA. And this is, I think, a pretty complicated topic. So let me talk about COBRA generally for just a moment before we get into the details of the American Rescue Plan. COBRA stands for the Consolidated Omnibus Benefits Reconciliation Act. And it gives employees and their families who lose health benefits the right to choose to continue group health benefits provided by their group health plan for limited periods of time, which is generally 18 months. And normally, the employee pays the COBRA group health premiums plus a small admin fee. Well, under the American Rescue Plan, 100% of these premiums are subsidized, meaning that the employer pays them and the employer is then reimbursed with tax credits against its payroll tax liability. So you'll recall that FICA credits are paid from or FICA taxes are paid from wages. It's 12.4%. Half is paid by the employee and half is paid by the employer. Well, the American Rescue Plan Act creates a 6-month subsidy period beginning today and going through September 30th, during which certain assistance-eligible individuals, and that's an AEI, an assistance-eligible individual, and their beneficiaries may qualify for a 100% subsidy for COBRA coverage. After September 30th, assistance-eligible individuals can remain on COBRA for the remainder of their qualifying period, but the premium won't be subsidized. But it does give them the opportunity to remain on COBRA. So qualifying assistance-eligible individuals pay no cost for monthly COBRA premiums for medical or for dental or for vision if they're eligible for COBRA coverage during the subsidy period. Now, the subsidy period does not extend the maximum COBRA coverage period. It simply suspends the assistance-eligible individual's obligation to make their premium payment for up to 6 months. So the one thing I will say is, unlike the FFCRA, which is voluntary, and the flexible spending account, which is optional for employers, these rules are not optional for employer-sponsored group health plans. All group health plans subject to COBRA, except for the FSA account, must provide this subsidized coverage. So one of the challenges for employers is determining who an assistance-eligible individual is. So let's look at that so you can analyze your own business. An assistance-eligible individual is somebody who had an involuntary termination of employment or a reduction in hours and whose current COBRA continuation coverage period would cover some or all of the subsidy period, or somebody who previously was employed by you and then previously declined COBRA coverage within the past 18 months, but is still in their COBRA window. So for example, if somebody declined 12 months ago, they might qualify for 6 months of subsidy. Or it could be somebody whose COBRA coverage was terminated because they failed to pay their premium, or somebody who's a beneficiary of an assistance-eligible individual. Now, on number 1, involuntary termination, the reason for the involuntary termination doesn't have to be COBRA related. People with involuntary terminations or reductions of hours within the past 18 months, so go back to November of 19, but who did not timely elect COBRA or who dropped COBRA, must be given a new COBRA election period. And any of these people may enroll and receive the subsidized coverage for the length of the subsidy period, which again begins today and goes through September 30th. And then the employer who sponsors the group health plan will be eligible for a tax credit in the amount of premium waiver, which creates, if you will, a free coverage for the employee and a tax credit for the employer. So let's look at who is not covered, who is not an AEI. Well, anybody who voluntarily ended their employment, so if somebody just quit, they're not an AEI. Anybody who is eligible for Medicare, and I'll just remind you that Medicare is generally available for people who are 65 and older, certain younger people who have disabilities, and certain people who have other conditions such as end-stage renal failure. They would be qualified for Medicare. An AEI is somebody who is not eligible for another group health plan, and an AEI is somebody who is not qualified if they didn't elect COBRA for this additional enrollment opportunity. In other words, it's not automatic. They do have to take some proactive action. So let's go through some examples of when somebody might or might not be eligible for COBRA under this expansion.
Okay, Amie, we'll put you to the test here. So first example, Sarah's company had a reduction in force in March of 2020. Sarah did not elect COBRA at that time. Is she eligible for COBRA now?
So when I read this question, a reduction in force is involuntary. In March of 2020 is 12 months ago. So I would say yes, she has the opportunity, a new opportunity to elect COBRA beginning April 1 today. And she would be eligible for 6 months of COBRA at the subsidized rate because March of 2020 was 12 months ago. Her total COBRA period would have been 18 months from March of 2020, and there's 6 months remaining in that 18-month period. So I'd say we would say yes, Sarah is eligible under this circumstance.
Thanks, Amie. The next example, Sarah's company had a reduction in force in March of 2020. Sarah did not elect COBRA at that time. In May of 2021, she became eligible for Medicare. Is she eligible for COBRA now?
Okay, so these facts are the same, except that in May of 2021, she becomes eligible for Medicare. And you'll recall I said that somebody who's eligible for Medicare is not an AEI, but she doesn't become eligible for Medicare until May. So she is partly eligible for COBRA. She has a new opportunity to elect beginning at April 1 today, and she's only eligible for the subsidy through the month of April. But once she's eligible for Medicare, she's not eligible for the COBRA extension after that date.
All right, thanks, Amie. And then a final example on COBRA. Sarah's company wanted to retain her during COVID, but she chose not to work beginning in March of 2020. Is she eligible for COBRA now?
So I would argue that she is not eligible for COBRA now. I would argue that if her company wanted to retain her and she chose not to work, that would be a voluntary quit, and anybody who voluntarily ended their employment is not eligible for COBRA for any period of time. So Kara, did I pass the test?
Yeah, good job.
Okay, good. All right, so let's talk about notices. The Department of Labor, which just got its new secretary, Marty Barton, the former mayor of Boston, is scheduled to provide model notices on April 10th. So in about a week, we're going to get some model notices. And the point of the notice is to tell, for the plan administrator to notify assistance eligible individuals that they do qualify for up to 18 months of subsidized COBRA, and to let them know when the 18 months is scheduled to end. Now, the plan administrator has the notice requirement. If you are a small employer and not subject to federal COBRA, the carrier may be responsible for providing the notices. Now, for those of our clients that participate in the LandrumHR Master Plan, LandrumHR will be sending out the notices. And if you have any questions regarding that, of course, your HR business partner is ready and willing to answer questions to help you out. It's anticipated that the first model notice on about April 10th will tell employees that the subsidized COBRA option exists and what the time requirements for election are. And it's anticipated that the second model notice will tell employees that they have that when their subsidy will end, and that will have to be given to employees between 15 and 45 days before the subsidy period ends. But it does provide a notice as to when the subsidy will end. So as if all of that wasn't difficult enough, in my opinion, the employer tax credit, retention tax credit, is maybe the most confusing part of this. The ERTC was originally part of the CARES Act, and it was designed to help businesses that retained employees during the pandemic. And like the other pieces of federal legislation that have passed over the past 12 months, the ERTC has evolved as Americans' needs have changed. So, as I said, it was originally designed to be part of the CARES Act, and it was designed to keep employees on between March 12th of 2020 and December 31st of 2020. And then the stimulus bill extended it to quarters 1 and 2 of this year, from January 1st of this year to June 30th of this year. And then the American Rescue Plan Act extended the ERTC to quarters 3 and 4 of 2021, but they look a little different than quarters 1 and 2. So the benefit comes in forms of a tax credit. And as I said earlier, the total amount paid into Social Security is 12.4% of employees' wages, and employers pay half and employees pay half. And then, of course, there's another portion for Medicare taxes as well. If you think your business might qualify for a tax credit under the Employee Retention Tax Credit, I would first suggest that you begin by speaking with your CPA or whoever provides your tax advice. And one of the cautions I want to give you is that you really need to look at quarters 2, 3, and 4 of 2020 and kind of put that in one bucket. And in another bucket, I would put quarters 1 and 2 of 2021. And then in a third bucket, I would put quarters 3 and 4 of 2021. And this is because for each quarter in each calendar year, different rules apply. And so you have to be very intentional about identifying which quarter and which year you're talking about to make sure you're applying the right rules. So I'm going to start by talking about the ERTC for 2020. And as I said, 2020 is defined as the beginning after March 12th and ending before January 1st of 2021. So it applies to those wages paid during that period of time. So for 2020, employers can be eligible to receive the tax credit in one of two ways. So first, if you had a business and your business had a reduction in gross receipts of at least 50% during the applicable comparison quarter of 2019. And so what I mean by that is you would look at a particular quarter in 2020 and you would compare your gross receipts from that quarter to the same quarter in 2019 and determine if there was at least a 50% reduction in gross receipts. And if there was, you're qualified to take the tax credit. So for example, you might look at Q1 2019 and compare it to Q1 2020 and determine if there's a 50% reduction in gross receipts. Or you might look at Q3 of 2019 versus Q3 of 2020. And you would want to do that for each and every quarter to make sure you're comparing 2019 quarter to 2020 quarter. So you can also be qualified to take the tax credit if your business, and these are the IRS's words, was fully or partially suspended, if you fully or partially suspended operations due to a governmental order directly related to the pandemic. So it's really, really important that you know whether any disruption of your business constitutes a full or partial suspension of operations, and whether any order that you require or you're relying on constitutes a governmental order under the ERTC. So again, I mentioned IRS's website earlier in their frequently asked questions. The questions regarding eligibility can be found at IRS FAQ number 40 and 28 through 38. So together you should work with your CPA using these FAQs to determine if you are eligible. So let's say you are eligible. Then what's the benefit? The benefit is that your business may claim 50% of each employee's qualified wages for that quarter. And there's a maximum per employee per quarter credit of $5,000 and a maximum annual credit of $5,000. And again, this is all for calendar year 2020. So let's move on to 2021. And 2021 is going to look similar, but it's actually more generous. I think that more employers are going to qualify for a couple of reasons. First, instead of having a 50% reduction in gross receipt requirement, employers are eligible if they had at least a 20% reduction in gross receipts as compared to the same quarter in 2019. So again, you would compare the first quarter of 2019 with the first quarter of 2021. And if there was at least a 20% reduction in gross receipts, your business might be eligible for the credit. And like 2020, employers are also eligible to claim the credits if they fully or partially suspended operations due to a governmental order. So the reduction in gross receipts is one way it's more beneficial to employers, but there's a second way. So in 2021, the credit is more generous because for either of the first two quarters of 2021, employers may claim 70% of each employee's qualified wages for the quarter, and there's a maximum credit of $7,000, not $5,000, per quarter, and a maximum credit of $14,000 per employee for the year. So it's a more generous gross receipts analysis. It's a higher amount of credit allowed, and so that's another way that it benefits employers. Now, you may recall in prior webinars, particularly the 2 or 3 or 4 that we did on the Paycheck Protection Program, how we said repeatedly that you may not double dip. And what we said was, if your business received a PPP loan and it was forgiven, you could not also apply for the employee retention tax credits. Well, that's changed. And now the employer retention tax credits can be claimed by employers whose PPP loans were forgiven. Now, one qualification I'll give you is you cannot use the same dollars for both. And what I mean is, if you had designated wages for a particular employee and those wages were forgiven, you can't claim the tax credit for those same dollars, which really makes sense if you think about it, because in reality, you didn't pay those wages. The government reimbursed you on a dollar-for-dollar basis through loan forgiveness. But if you did have some wages that weren't forgiven, maybe you used your mortgage interest credit and some of the other allowables, but if you had wages that weren't forgiven and you paid those wages yourself and you didn't have a forgiveness for those, then you can take a tax credit on those wages. So while we're talking about wages, let's look at what wages qualify for purposes of the ERTC. So again, I would caution you, we have to look year by year. So what is a qualified wage in 2020? Well, the answer is going to depend on the employer size. The threshold is whether an employer is above or below 100 full-time employees. So if an employer has 100 or fewer full-time employees, qualified wages are those wages paid during the calendar quarter where your business was fully or partially suspended, or those wages paid during any calendar quarter when the business was experiencing a significant decline in gross receipts. So if you're a larger business and you had more than 100 full-time employees, only the wages that were paid to employees who did not perform services at all during that time would be qualified wages. So again, just like we spoke a moment ago about 2021 being more generous, this is another way, the definition of qualified wage is another way that 2021 is more beneficial to employers than 2020 was. So for the first 2 quarters of 2021, employers with 500 or fewer full-time employees may claim wages which were paid during any calendar quarter where the business operations were fully or partially suspended due to a governmental order or where there was a significant drop in gross receipts. So all that can be qualified wages. So I say it's more generous because there are a lot more businesses with 500 or fewer employees than there are that only have 100. So more businesses are going to qualify for 2021 than did qualify for 2020. So Kara, let's put ourselves to the test and do another example.
Sounds good, Amie. So this example on the ERTC is in 2020, XYZ company had 7 employees. Each earned qualified wages of $25,000 per quarter for a total of $100,000 a year. XYZ had a 60% reduction in gross receipts when it compared each quarter in 2019 to each corresponding quarter in 2020. The employer's portion of Social Security taxes are 6.2% and Medicare taxes are 1.45%. So we threw some math in here for you, Amie.
Right. Well, luckily we have a Dynamo finance team to help us work all this out. But the analysis would be, first, do they qualify by virtue of the gross receipts? And here we're talking about 2020, and they had more than a 50% reduction in gross receipts for quarters 2, 3, and 4 when they compared those quarters to 2019. So that qualifies them to seek credits for the quarters. Now there's a maximum of $5,000 per employee for the entire year. Therefore, the total amount of credit that XYZ company could claim would be $5,000 maximum times 7 employees, or $35,000. Now, one thing that's important to note, XYZ's qualified wages can include the employer portion of qualified health insurance if it didn't have sufficient wages elsewhere to make up that money. It could be included as qualified wages. So Kara, did you want to follow up with another poll question and see how everybody's feeling about this?
Yes. So our final poll question for the day. Amie did a great job of giving us some highlights on the ERTC, and love to ask the attendees one final question. Do you plan to seek tax credits under the ERTC from what you know today? So yes, no, or unsure. And just give a few more seconds. Really appreciate all of our attendees responding so well today. Gives us a great idea. There's a lot about our clients or anyone that's not our client that's on and what you're thinking and how we can help tailor future webinars to deliver more information. All right, so I'll close this one out and Amie share with you in the audience. Mixed bag here, yes, 26%, 26% no. So yes and no pretty even, and 48% still unsure.
Yeah, so those 48% probably want to work with their CPA and determine whether they're eligible, and if they are, if it is worth their time to do that. Now, at LandrumHR, we have developed a process to help our clients obtain the credits that our clients and their CPAs have determined that might be owed to them. And I want to explain that really quickly. For quarters, and of course, like I said, we have to look quarter by quarter and year by year. So that's the reason we have 3 separate dates. But for quarters 2, 3, and 4 of 2020, those credits will be claimed on LandrumHR's IRS Tax Form 941X. And this is because LandrumHR has already filed its Form 941 for the year 2020. And so now we must amend that tax document. And once received from the IRS, the credit will be provided to you. So for quarters 1 and 2 of 2021, Clients will file the Form 7200 with the IRS. LandrumHR will then reconcile those credits with our Form 941 because the Form 941 is the link between payroll records and IRS tax records. But then the IRS will issue the credit directly to the client. And then I want to tell you real quickly about the deadlines. For quarters 2, 3, and 4 of 2020, the deadline for the receipt of all documentation is April 30th of this year. For Q1 of 2021, the deadline is coming up shortly. It's April 9th. And for the period of Q2 of 2021, the deadline for receipt of all information is June 30th of 2021. And when we learn more about Q3 and 4 of 2021, we will update that information. One caution I want to extend is that the IRS has not provided any expected dates for receipt of the credits. And in fact, we have heard talk in the industry that it will likely take a very long time to see these credits. So while the credits are a really, really great thing for businesses to get, we may have to be patient. They may not come anytime in the near future. And we have additional information about the ERTC. We have a blog, we have a video on our website, and then of course our HR business partners can answer questions about the ERTC and any of the other topics that we've covered today as well.
Thanks, Amie, and thanks for listing out these resources for us. I know we've just done quite an extensive amount of webinars in the last year, and we do have recordings of those, and we've got our blogs and articles out there. Please feel free to visit our website. Amie, thanks so much for the presentation today, and again, all the work that you and the legal team, the compliance group, finance, our HR business partners do every day to work with our clients and for us to get these webinars out, not just to our clients, but also in all the communities that we serve. So we have a couple of new webinars that are coming up, a couple of events. First, on April the 27th, Building an Ideal Talent Pipeline, talking about inclusion, diversity, equity, and authentic leadership. On April the 29th, we'll continue our quarterly series with Brian Wilkerson and the consulting team on workforce and economic trends, and we'll be focusing on Q1. So I hope that you can join us for all of those things. You can find out more information on our website, LandrumHR.com and HRQinc.com. So on behalf of Amie and myself, all of LandrumHR and HRQ, thanks for joining us today.